starting in 5 seconds. The plaintiffs claim that the Indian defendant number 2 company is under the control of wrongdoers. They further claim that defendant numbers 8 to 10 were in active collusion with defendant numbers 3 to 7 and that they have joined hands to deprive defendant number 2 of its beneficial interest in the suit share, namely 6% of shares of the Indian company. The plaintiffs have further stated that they came to know from newspaper reports that the equity of defendant number 1 was to be sold to private equity investors through a bidding process and that defendant numbers 3 to 7 along with the defendant numbers 8 to 9 were attempting to sell their investments in the Indian company. It was urged that in case such a sale was to happen, defendant number 2, which had financed the purchase of such shares, would be put to loss if its beneficial interest was not recorded in the books of the Indian company. While filing the suit, and the plaintiffs had filed application number 292 of 2018 seeking leave to institute the suit within the jurisdiction of the High Court of Judicature at Madras. In the affidavit filed in support of that application, the plaintiffs had stated that they had sought a declaration that defendant number 2 had a beneficial interest over 6% of shares of the Indian company. However, the shares might be alienated. It was further stated that substantial part of the cause of action arose within the jurisdiction of the court where the registered office of the first defendant was located and where it carried on business. Further, the entire subject matter of the suit was the shares of the Indian company which are held by defendant numbers 3 to 7 and that defendant numbers 3, 5, 6 and 7 normally reside in Chennai. It was further stated that the correspondences between the plaintiff number 2 and the Indian company through defendant number 10 also took place in Chennai, claiming on this basis that substantial part of the cause of action arose within the jurisdiction of the High Court. Leave to institute the suit was sought. The single judge court granted leave. As noted above, the contested defendants filed applications for revocation of the order granting leave to the plaintiffs. The Indian company in the affidavit filed in support of A number 1387 of 2018. It was urged that order granting leave should be revoked on this ground itself. It was further stated that there are no disputes with respect to the ownership or management or shareholding of the Indian company. It also took the stand that the plaintiffs are neither the shareholder nor the directors of the Indian company and therefore they had no right to sue and consequently the suit itself is not maintainable. It also averred that the disputes between the plaintiffs and defendant numbers 3 to 7 arose around 2013 and the suit had only been filed in the year 2018 and consequently the suit was barred by limitation. Another objection was that the plaintiffs had filed the suit when private equity investors had shown interest in purchasing shares of the Indian company and the same was an abuse of process of law. Maintainability of the suit was also questioned on the ground that it was barred by Section 89 of the Companies Act 2013 and Section 180C 7C of the Companies Act 1956. Somewhat similar stand was taken by other contesting defendants in supporting of the prayer for revoking the leave and to rejecting the plaint in CS number 33 of 2018. Defendant number 2 also took the plea that it was not interested in seeking the relief claimed in the plaint. Defendant number 2 is the beneficial interest holder of 6% of shares of the Indian company. Counter affidavits were filed by the plaintiffs with respect to these applications, reiterating that they had the locus that the suit is within the period of limitation, that the court had jurisdiction to adjudicate the issues, and that the suit that had been filed with bona fide intent. The learned single judge dismissed the applications filed by the defendants seeking to revoke the leave granted to institute the suit and to reject the plaint inter alia, holding that the allegations pertaining to fraud would have to be decided in the suit. He further observed that there were factual issues that were to be gone into, and sections 187C and 89 of the Companies Act, which may be bar the reliefs but would not bar the suit. The aforesaid order of the learned single judge has been reversed by the division bench wide common judgment dated August 03, 2018. It has allowed the appeals filed by the contesting defendants and set aside the common order of the single judge, thereby revoking the leave granted by the single judge in the case. Stop. Starting in 5 seconds. Mr. Vice Chairman, sir, at the outset, I must express my thanks to the honorable members on both sides of the House who have participated in the discussion on the 10th 5-year plan document. Honorable members will very kindly appreciate that within the short time at my disposal, it will not be possible for me to clarify all the points which they have raised during the course of the discussion. I am going to confine my remarks to certain important aspects of the discussion, though I have taken note of almost all the points which honorable members made during the course of the discussion. At the outset, I must also say that one of the honorable members was pleased to ask what is the purpose of having this kind of a discussion 1.5 years or almost 2 years after the plan has started. I do not know whether honorable members do recollect that my predecessor Mr. Tiwari had circulated a note to all the members of this house, particularly about the 10th plan framework, and he expected that the honorable members will be able to send their remarks to the minister and also to the planning commission, so that before the draft document of the 10th plan is prepared and finalized, their views could be taken into account. How many members sent this kind of information is a matter which I will have to inquire into, but that exercise was gone into, and now the plan was finalized in February 2001, and thereafter we have taken the earliest possible opportunity to see that the plan is discussed in both the houses. Sir, I am aware of the fact that the international situation and also the internal situation in which this 10th 5-year plan has been finalized. This will definitely have some kind of an impact on the plan document as it was prepared, and how we will be succeeding in trying to avoid the adverse effects it might have on the achievement of the physical targets that we have set for ourselves at the end of the 10th 5-year plan. Sir, there are 3 points which were mentioned by all the honorable members. The first was that the plan was prepared with 1999 2000 as the base year, and thereafter there has been a price rise of a considerable order. Sir, the first thing which I would like to clarify is about the inflationary trend which has set in. One of the honorable members, Sri Shankar Ghosh, a very experienced member of this house who had also been in the planning commission and knows that intricacies of how the things are being worked out, has been pleased to state here that the rate of inflation is very high, and added to that the balance of payments position is going to be very bad compared with the percentage that we have worked out for the 10th plan as a whole. For imports, for the first year the import bill has risen very high. Then how is this assumption going to be correct? That is the point, and a very valid point which he raised during the course of the discussion. Sir, he also mentioned about the Honorable Finance Minister making his speech at Kanpur, where he seems to have made a reference that a little inflationary trend is a kind of a stimulant to the economy. Sir, the inflationary trends we cannot view in isolation. Honorable Sri Shankar Ghosh will definitely agree with us that there are two factors which will have to be taken into account. The first factor is the international situation which is now obtaining. Secondly, whether we like it or not, we have to import the oil products. If they are to be imported, can we take a serious view of the situation? That is a thing which I am sure most of the honorable members there will be able to appreciate. The second aspect is, why is it that we have such a high import bill in 2000-2001 when the plan itself commenced, and when we are talking in terms of 9% immediately in the very first year it jumped. I am sure that most of the honorable members are aware of the fact that it is on account of the kind of legacy that this government got. I would not like to delete on this that issue, but the fact of the matter is that the agricultural production had gone down. Even in the industrial sector, there was a decline of 1.4%. The coal production had considerably gone down in terms of production, and the electricity generation was at the lowest. If we had to make a beginning, which in fact is within the control of the government of India, with these infrastructural facilities which will have to be provided both in the agricultural sector and the industrial sector, concerted efforts will have to be made. Stop. Starting in 5 seconds. Mr. Deputy Chairman, the development of rural areas and improvement in the quality of life of the rural people has been of primary concern in the economic planning and development of the country. There is a growing realization that economic development and progress made by the nation in diverse fields would in reality be meaningless if they fail to translate it to better and dignified life for the majority living in rural India. In order to correct the developmental imbalances and to accord due priority to rural areas, the Ministry of Rural Development is implementing a number of programs aimed at development of rural areas with a focus on weaker sections. The rural development programs have been streamlined and strengthened. A number of initiatives have been taken by this ministry in the recent years for creation of social and economic infrastructure in rural areas to bridge the urban rural divide as well as to provide food security and to fulfill other basic needs of the rural poor to match with economic liberalization and structural adjustment and to provide for safety, especially for rural poor. Top priority has been accorded to rural development in terms of increasing the allocation of resources for the implementation of poverty alleviation programs. The allocation fund for the rural development programs has been increased for the 10th plan. The creation of employment opportunities with food security has been an important objective of developmental planning in India. The relatively higher growth of population and labor force has led to increase in the volume of unemployment and underemployment from the one plan period to another. With the working age population growing quite faster, the number of unemployed Indians is almost doubled. The declining employment rate shows that our growth process is failing. The real wages have been declining. The government of India aims to bring employment through wage and self employment into a larger focus with the goal of reducing unemployment and underemployment to a negligible level and of providing food security against hunger. Such an approach is necessary because it is realized that larger and efficient use of available human and other resources is the most effective way of alleviating poverty, reducing inequalities, improving nutritional level and achieving a reasonable high pace of economic growth to make a dent on the prevailing poverty, unemployment, and a slow growth in the rural economy and to provide food security to facilitate faster growth in rural areas and to increase opportunities of employment to provide greater importance of wage employment in rural areas. The National Rural Employment Guarantee Act was passed by the Parliament for securing livelihood of the people in the rural areas by guaranteeing 100 days of employment in a financial year to a rural household. This act makes a shift in the whole strategy of existing wage employment programs because this act is not just a scheme, it provides a legal guarantee, it provides a social security for the weaker sections and opportunity to combine growth with equity in the process of employment generation assets which build up and strengthen the livelihood raise pace of poor. Within 5 years the act will be extended to the whole country. Sir, the National Food for Work program was launched in the year 2004 in the most backward districts of the country, identified by the Planning Commission in consultation with the Government of India and state governments. The need for the new program was felt because the existing resources were not sufficient to meet the requirement of additional wage employment for most backward districts. Moreover, it was felt that additional resources should be used into some focus areas like drought and water conservation, which is the main problem in some states and a major cause of backwardness on certain regions. Some areas are flood prone, and measures for flood control require special attention in these areas in a planned manner. The states were finding it difficult to provide state share of funds, and therefore a centrally sponsored scheme was proposed so that the investment in backward areas does not suffer because of lack of resources available with these states. The objective of the program is to provide additional resources opportunity from resources available, that generation of supplementary wage employment, and provide food security through creation of need-based economic, social, and community assets in these districts is further intensified. Sir, now I come to the program which aims at building a nation with progressive and prosperous rural India. It will be a time bound plan in the areas of irrigation, road, rural housing, and water supply. Government has set target to be achieved under these goals. Stop. Starting in 5 seconds. The prosecution and the complainant will also, of course, be given an opportunity to examine their own witnesses and to cross examine the witnesses who have been got examined on behalf of the accused, and for that purpose notices of the proceedings before the JJ board shall be served on the complainant, as it is possible that in some cases the prisoners mentioned in the state's list may indeed be below 18 years in age on the date of offense, but as the basis for arrival at the conclusion in the state's list were usually some preliminary medical examinations and no detailed steps for ascertaining ages had been taken after hearing both parties, and it cannot be ruled out that in certain cases extraneous measures may have been used for reducing the ages. We think that such an exercise as detailed above, wherein the ages are ascertained after hearing both parties, was needed. The said exercise is to be completed within a period of 2 months, and the reports submitted to this court on its next listing. The district judges or district legal services authorities shall take strict measures in future for ensuring that prisoners below 18 years of age on the date of offense are not lodged in adults' prison in violation of the Juvenile Justice Act and rules. So far as District Allahabad is concerned, we direct the District Judge Allahabad to permit Rohan Gupta, advocate, to visit and interview the concerned prisoners for the purpose of ascertaining their ages and for submitting the report to the court on the next date of listing. It was further submitted by the learned counsel for the petitioner that so far as the prisoner Raju is concerned, whose age was determined to be below 18 years, he was earlier lodged in Faizabad jail and was subsequently sent to the special home, as he was convicted as far back as in the year 2001 in a case under section 302 IPC. The respondents should inform this court about the total period spent in jail by this prisoner, and in case it exceeds 3 years, the basis for his being presently detained in the special home. Thus, wide the order referred to above passed in a public interest litigation being criminal, the Allahabad High Court directed the Juvenile Justice Boards to hold an inquiry for determination of the age of prisoners. The medical board subjected the writ applicant herein to the x-rays of the skulls, etc. Upon medical examination of the writ applicant herein, the medical board gave its report certifying that the date of the commission of the alleged offence, the writ applicant could have been around 15 years of age as on the date of the medical examination. The convict was around 56 years of age. It appears that some time later, the writ petition applicant was in a position to obtain a document in the form of family register issued under the UP Panchayat Raj Rules 1970. In the family register certificate, the year of birth of the writ applicant herein is shown as 1968. If 1968 is the correct birth year of the writ applicant herein, then in 1982 he was about 14 years of age. In such circumstances referred to above, the writ applicant is here before this court. He claims that as he was a juvenile on the date of the commission of the alleged offence sometime in the year 1982, he could not have been put to trial along with other co-accused and should have been dealt with under the provisions of the Juvenile Justice Act as prevailing at the relevant point of time. It is the prayer of the writ applicant that the respondent state be directed to get the claim of the writ applicant in regard to the juvenility verified through the concerned sessions court or the Juvenile Justice Board. Mr. Rishi Malhotra, the learned counsel appearing for the writ applicant, vehemently submitted that although till the dismissal of the special leave petition by this court with order the convict had not raised the plea of juvenility, yet the law permits him to raise such a plea even at this point of time, having regard to the provisions of the Juvenile Justice, Care and Protection of Children Amendment Act 2011. It is submitted that there is clinching evidence on record as on date in the form of certificate issued by the medical board as well as the family register to indicate that in the year 1982 the writ applicant could be around 15 years of age. The learned counsel would vehemently submit that there is no good ground to discard the certificate issued by the medical board as well as the extract of the family register. To forfeitify the aforesaid submissions, the learned counsel seeks to rely upon a three-judge bench decision of this court in the case of Ghulam Hossain versus State of West Bengal, reported in 2012 10 SCC 489. Stop. Starting in 5 seconds. Mr. Chairman, the discussion on the resolution put forward by Mr. Sinha and the substitute motion put forward by Mr. Das has turned out to be a discussion in the nature of a journal discussion of the budget of the All India Radio. I do not want to go into all the considerations which have been put forward, but I want to say one thing about the substitute motion that has been put forward by Mr. Das. I think In India, we are developing a passion for having committees and commissions. We want a committee or a commission for every blessed thing that there is in India. I think there are millions and millions of things in India. I would say that before we think of having any other commission or committee appointed, we should first of all read the reports of those committees and commissions which are before us, digest them and take action on them, and then think of doing something else. For instance, what is the record of the Ministry of Broadcasting in the matter of the Film Inquiry Committee report? They have now the Press Commission's report. The two bodies have been set up by this ministry. What action has been taken on the report of the Film Inquiry Committee, and what action is going to be taken on the report of the Press Commission? I think that the Press Commission's report may be thrown into cold storage. We will not allow it to be thrown into cold storage. I know what has happened to the report of the Film Inquiry Committee. Therefore, I say that this passion for committees and commissions should be curbed, and we should not run away with the idea that the commissions will provide the panacea for all our ills and that a committee will cure all our difficulties and troubles. Therefore, I think it is no use appointing a commission at this stage to go into the question of broadcasting. There is another thing. My friend has been asking for the appointment of a cooperation. I am a member of the Lok Sabha, and if you ask me to be a part to the appointment of a corporation, it would be tantamount to this that I abrogate almost all my responsibilities and privileges as a member of the Lok Sabha. I was saying that the need is for direct control. The control should not be slackened for a minute. Unless it is done, I am sure the lines on which these persons want the radio to develop will not be possible. Why I say that there should be a perpetual vigilance on the part of the parliament is for this reason. If there is corporation, my honorable friend, the Minister of Information and Broadcasting, will be the most happy person. He will have all the privileges which he is having now, and he will not have the necessity of coming before us to give answers to our questions and to submit to us reports. He will have all the privileges and very little responsibility for that. I say that the control which the Parliament exercises over the All India Radio at the time of the budget is sufficient to make these people wake up. It is sufficient to make these people active who are slack. It is sufficient for those people who practice nepotism to be fair, and if there is a corporation, the whole thing will go away and we shall not have any control over the All India Radio. Now we have control over appointments through the Public Service Commission, and if we have a corporation, I do not think you will have that control. We have control over the All India Radio on account of the Public Accounts Committee and the Estimates Committee. My friends have said that the Estimates Committee has suggested 92 improvements to be made in the All India Radio. I think that shows how effectively and how comparatively the work has been done. When work of that kind is being done by the estimate committee and the public accounts committee, and when the whole thing comes before the house, I do not see why we should have a corporation of this kind. We in India in this transitional era are suffering from self contradictory impulses. On the one hand, I see on the floor of this house something being said that we should not take this country or that country as our model, and on the other hand, a gentleman wants us to follow the BBC model or some other model. That is a self contradictory impulse. Somewhere in the 2004 issue of this quarterly, I find an article not eulogizing the corporation but an article on the subject of the ills of the British Broadcasting Corporation. The gentleman has gone into the question and given us the reason for that and also the remedies for that. I would therefore say that we do not need a corporation. Stop. Starting in 5 seconds. Madam, I now come to the activities of oil exploration. Our aim ultimately is a complete stoppage of import of crude oil. With a view to do it, we are now intensively carrying on oil exploration both offshore and onshore in the country. As the House knows, the activities of offshore explorations are increasing and there are very good prospects of getting oil. Next year, we hope that production from the offshore will be something between 1 million and 2 million tons of oil. By the middle of the next year or by the third quarter of the next year, our production of crude oil from the onshore areas is also likely to increase by about 1 to 2 million tons. So, just now, when we are importing about two-thirds of our consumption, we hope that by the end of the next year, this proportion will be substantially reduced. It is quite possible that we may then produce about 40% of our crude oil by the end of this year and import about 50%. If discovery of oil and production program goes on like this within 3 years, we hope the situation will very much improve. By the end of the next year, we hope we shall be able to produce as much oil as we would require. Madam, such a situation in the exploration is due to the fact that the Oil and Natural Gas Commission has of late made rapid advances towards new technology both onshore and offshore. I am glad to inform the House that we are now knowing much more the difficulties of oil exploration than what we knew about a few years ago. We do not hesitate to exchange knowledge with those who have it, although there are sometimes difficulties in bargaining with such parties who know more about it than us. Now, with regard to increasing the number of refineries, it is very difficult just now to commit the government to anything like that. There are 2 refineries in Assam, a third one is coming up. With these, we hope to process as much crude oil as will be possible for us to do. We are already committed to transport 2 million tons of crude oil to Bihar. Madam, I would like to say a few words about the Assam oil situation. Oil exploration in Assam is increasing, and I want to assure honorable members that both the refineries are being expanded. At present, we are actively engaged in planning for the expansion of these refineries. The petrochemical industry is being planned, and we hope in the next 2 or 3 years there will be sufficient expansion. Madam, there is one more point which was raised by my honorable friend. I want to inform the House that the public sector units are increasing the quantity and quality of our medicines. These are badly required. The House may be aware that very recently there was acute scarcity of blood pressure medicines. These tablets were neither available in our country nor are we getting it from the Western countries. We managed to get the bulk product, and now you will be glad to know that the public sector is producing blood pressure tablets. In this manner, we are increasing our sphere of activity. The honorable member will agree that how soon we acted on the information supplied by him. Further, fertilizer prices have already been reduced by about rupees 80 depending on different types of fertilizers. There is a large program of having plants under public sector fertilizer industry. With the discovery of oil and gas in Bombay High and elsewhere, the position of fertilizer production in public sector has eased. So far, we have been depending on fuel oil, coal, and also some quantities of naphtha for producing fertilizer. We did not want to import furnish oil and naphtha for our fertilizer plants. As more oil and gas are expected to be produced from Bombay High, we hope it will be easier and cheaper for us to produce fertilizer. We hope to get as much gas and oil from these prospective areas as is possible so that by the end of the next year we may be able to have 8 million tons of fertilizer for our people. Madam, I have nothing more to say. I only hope that this program, which is initiated by the Prime Minister, will receive very serious consideration not only from our party but from opposition party also. So far as our party is concerned, we are very seriously engaged in modifying our own organization, bringing about improvements in our own organization, creating a new pattern of cooperation between the government and the people to move faster to satisfy the aspirations of the people as well. Stop. Starting in 5 seconds. Madam, I support this bill, but at the same time, I would like to draw the attention of the government on certain important issues. This enactment is now repealing the earlier enactment, which was a very successful enactment made during the period of Srimati Indira Gandhi when she implemented the 20-point program. The Standards of Weights and Measures Act was brought by her. It gave a lot of strength to the common man and consumers. Throughout India, people were very happy that they are going to get clear weight measures and they are going to get the materials in a proper method. That was also imposed as part of the successful emergency rule, but at the same time, the enforcement was subsequently made by way of another enactment during Sri Rajiv Gandhi's period. Now we are taking both the enactments together in the new bill, but I would like to draw the attention of the government that we have missed the main part, that is, this enactment is for the consumers, for the people, but there is no participation for the consumers or for the people in any of the positions throughout the enactment. Even now, we are thinking only in the name of enforcing things as if we are having all powers to enforce certain things and we have got very big machinery to enforce. But it can never happen. The country is a very big country. There are more than 100 crores of consumers. We cannot find out how the consumer is going to benefit, in which way this enactment is violated by a particular group of people or corporate bodies or multinationals. We are not having examples to say that multinational companies were prosecuted and their share has fallen due to enforcement of a particular provision of this act. We cannot cite even a single instance that a very popular company which has a wide consumer base in India is not following the rules of weights and measures and therefore it was prosecuted or its director was prosecuted. We have to bring awareness among the people about their rights. We can very easily say that print and electronic media fight every time to increase their ratings, even if there is a small violation here and there. They are making it a live telecast but not consumer issues. It is only the government's agency which are bringing awareness among the people. They are telecasting advertisements, they are educating consumer how to measure a particular product and see whether it is properly measured or properly packed. They also educate that if there is any violation, the consumer can go to the consumer court and claim damages. Similarly, if you think the other way, then the consumer who is affected by that, who is not getting a proper measure or weight of a particular product after spending some money, and if he is not satisfied, he should have a right to prosecute that retailer or the company which has that brand name or the person has packed it or weighed it or who has certified it. Here we are not giving that right to the consumer. The consumer participation is totally absent in this bill. We have to draw inspiration only from the Consumer Protection Act. When we are making legislation, we can very well bring that provision in this and give proper power to the consumer. When you are giving power under clause 15 of the bill, I hope the Honorable Minister can understand the common man. Therefore, the common man has to be heard. I hope the Honorable Minister might have noted this. At least he has to bring some amendment giving power to consumer to prosecute when there is violation of law. Madam, financial commitment of rupees 25 crores has also been mentioned in this bill. I would say that money committed should not be used for salaries of employees alone. When we are enforcing this kind of legislation, we have to recruit many people, but at the same time, we must spend a considerable amount of money for bringing awareness among the consumers. We have to educate the consumer that he has got such and such rights. I find a small word included under clause 15 of the bill, but it is not giving a clear meaning that rights are given to the consumer. When we are making enactment, I feel we have to think about the international standards. The international standards are made for the people and by the people. They are looking after it. The regulatory authority is only guiding and helping them to see that enforcement is properly made. We think that this can be enforced only by an officer. That will never happen. They will go only for statistics purpose as to how many cases have been registered every week. Similarly, I would like to request the government to think about punishing companies not just by way of a fine. Now, under the proposed bill, compounding system of penalty has also been provided. It is very easy for them. They will pay rupees 25,000 or even any amount for that matter through its representative. It is very easy for any corporate body. If it is so, how the director is going to be liable? He takes the plea that he is not knowing it. It is given by a retailer or its agent. Sir, finally, I would like to conclude with the observation that when we are making a law, it should be a comprehensive one. We are already having the Bureau of Indian Standards. They are giving the certification. The private agencies are also coming up. They are also putting the standards. Now, the fashion of the world more or less is giving everything to the professional bodies rather than keeping everything with the government. Rather than keeping the powers with the government, if we go it to the actual stakeholders, it would be a good enforceable enactment. Stop. Starting in 5 seconds. It is a pleasure for me to be here for the 7th convocation of the Indian Institute of Technology, Hyderabad. This occasion is a double celebration as it coincides with the 10th anniversary of the opening of the institute. Let me begin by congratulating the IIT Hyderabad community for these landmarks. For the graduating students, today is a special moment. It is the result of years of hard work and dedication on your part and on the part of your teachers and professors as well as your families. The energy and enthusiasm of youth combined with a solid foundation is a very effective combination. It can take an individual very far. As fresh IIT graduates, you are entering a world and an India packed with opportunities. There is so much you can do and so much you can achieve for yourselves, for your families, for society at large, particularly for those less fortunate than you. Please dream big and aim high and please take risk. The time to do it is now. Like individuals, institutions are very dependent on decisions taken in their formative years. IIT Hyderabad is young, it is only 10 years old. It too is defined by energy and enthusiasm and has built a solid foundation. Today, you have 2,500 students, one in five of them being a young woman. The institute has a strong postgraduate program with 30% of students pursuing a PhD. These are commendable figures, but the question is what next? The road you take today will determine your future not just for the next few years but perhaps for the rest of the century. That may sound like an overstatement, but do consider some of the world's major universities or even the older IITs, your peer institutes. Their achievements over several decades have been shaped by the trajectory they took in their earliest days. As a second generation IIT, it is important that you borrow from as well as learn from the models of the past. Conditions are different from the 1950s and 1960s. India has changed. Technology and the very discipline of engineering have evolved. Our aspirations are no longer limited to the heavy industrial base that we created 6 decades ago. Rather, IIT Hyderabad has to remain relevant to the fourth industrial revolution that will write the script of the 21st century. I am happy to learn that a start has been made by setting up a network of centers for research and promotion of entrepreneurship at this institute. These include the Center for the Healthcare Entrepreneurship, the Center for Cyber Physical Systems and Internet of Things, and Fabless Chip Design Incubator, and other initiatives that fall under the umbrella of the TIS Foundation. Collaborative research is being carried out in areas of widespread utility such as 5G technology, affordable housing, and information networks for natural disaster mitigation and recovery. MOUs with leading international universities and R&D agreements with Japanese industrial corporations are also worthy of appreciation. Ladies and gentlemen, the best scientific universities and institutions of learning are not just teaching shops or degree factories. Increasingly, they are sources of innovation and incubators of technology and technology driven startups. The knowledge ecosystem of public investment in science, academic institutions, and universities, research laboratories, commercial applications, and private enterprise has an almost magical potential. Its best example is, of course, Silicon Valley in the United States. At the core of Silicon Valley are basic science and technology campuses and their talented faculty and students. This IIT has been set up in a city and in a metropolitan area where several elements for such an ecosystem already exist. IIT Hyderabad, in a sense, is the element that completes the picture. Hyderabad has a long tradition of scientific discovery and application. In the 19th century, Ronald Ross, who won the Nobel Prize for Medicine for identifying the mosquito that transmitted malaria, did pioneering work here. After independence, Hyderabad became a location of industrial manufacture. It saw vigorous and far-sighted investments by the public sector and then the private sector. Gradually, the city's reputation grew as a research center. Before coming here, I called for details from the Council of Scientific and Industrial Research, the Department of Science and Technology, the Department of Biotechnology, the Department of Atomic Energy, the Defense Research and Development Organization, and the Indian Space Research Organization. Between these institutions, I am told there are as many as 19 research facilities and laboratories in Hyderabad. I have not even mentioned the private sector. Hyderabad based companies are engaged in cutting edge research and manufacture of biopharmaceuticals and vaccines, and separately in the field of information technology. Stop. Starting in 5 seconds. Mr. Deputy Speaker, sir, I rise to express my views on this important bill, namely the Food Safety and Standards Bill. When we talk about food and food safety, we are definitely concerned about the health and safety of human beings. Good food means good health. Healthy citizens mean a lead to a healthy and wealthy country. The main objectives of the bill are to consolidate the laws relating to food and to establish the Food Safety and Standards Authority of India for laying down science based standards for articles of food and regulate their manufacture, storage, distribution, sale, and import to ensure availability of safe and wholesome food for human consumption. Sir, as the bill is the outcome of the discussions on various meetings of parliamentary and ministerial committees, the Food Safety and Standards Authority should be made an autonomous body. Also, it should be headed by a scientist or an expert in the field of agriculture. Sir, you are aware of food adulteration. We do not get pure drinking water in rural as well as urban areas. Even when we pay and purchase water, we are not sure whether the water is pure or of good quality. In view of the fast growing food processing industry and liberalized trade, we have to ensure that the consumers are not cheated by the sale of substandard goods, and also that the country is not made a dumping ground for substandard imported goods. There is mushrooming of foreign companies, multinationals, Chinese, and fast food restaurants in India. They use various food additives which are very much harmful, particularly to children. So, the functions of the proposed Food Safety and Standards Authority are to be lauded. There are prescribed standards and guidelines for articles of food to regulate and monitor manufacturing, processing, distribution, and sale of food so as to ensure safe and wholesome food for the people. The Food Authority shall establish or recognize by notification one or more referral food laboratories to carry out the functions entrusted to the referral food laboratory by this act or any rules and regulations made thereunder. As far as the sample testing is concerned, there should be strictly a time frame of getting the verification report within the shortest period of time. Today, the food sector in the country is governed by a multiplicity of laws under different ministries. As such, it was felt that we should have a single regulatory body and an integrated food law. Sir, I strongly feel that every stage in the food chain needs to be standardized, and also there should be strict ban on advertisements on print as well as electronic media, which lead to unfair trade practices. Person or agencies engaged in any unfair trade practices for purpose of promoting the sale, supply, use and consumption of articles of food should be heavily punished. This type of trade leads to consumption of poor standard food, which leads to consumption of poor quality food and harm to the consumer. So, today the developed world has got strict food safety and standard laws. We too should have such laws so that the developed world does not take advantage of our weak laws in this field. There should be sample testing units which can give immediate reports after the verification of the sample food to be used by the consumer. I would suggest addition of clauses in the bill to ban such type of fast food multinational companies restaurants found guilty of using harmful additives and preservatives. Their licenses and registrations should be cancelled for their misdeeds. So the bill makes provision for graded penalties where offences like manufacturing, storage, and setting misbranded or substandard food are punished with fine and more serious offences with imprisonment. Sir, as per the packing and labeling of foods, no person should manufacture, distribute, sell, or deliver for the purpose of sale without a specified label. There should be a specific standardized agency for different food items. So, the domestic market for processed food is growing at a healthy 15% a year. However, it is very unfortunate that there is a complete lack of quality control in India's food sector. There is an urgent need to check food adulteration, food poisoning, and contamination of food. There is no denying the fact that available food should be safe, hygienically produced, and wholesome with right nutritional configuration. Sir, the implementation of the Act is going to be a big challenge as there are not enough laboratories that can do sensitive and detailed testing. On the whole, the bill is very timely and strengthens the law which is badly needed today. I wholeheartedly support this bill. At the end, sir, I thank you for giving me an opportunity to speak on this bill. Stop. Starting in 5 seconds. Mr. Deputy Speaker, sir, before I say anything about defense, I would like to congratulate the Home Ministry on the splendid work it has done in connection with the improvement of the conditions of the scheduled caste and scheduled tribes. The present Home Minister and his ministry are not spending money on good schemes as used to be done in the past. They have got very many schemes and those schemes are really worth spending lot of money. They are really for the benefit of these communities. I was going to ask the Home Ministry to set up a separate fund for the construction of houses for these communities since the ministry concerned with housing had completely neglected this problem which is facing these communities. Even the Planning Commission in the last 5-year plan has not done much in this regard. I think even in the 10th 5-year plan, there is no definite plan for providing housing facilities for the scheduled caste and scheduled tribes. But since the housing minister has promised that he is going to constitute a board to go into these things. I do not think there is any need for me to stress this point anymore. About the board which is going to be constituted, I would definitely like to say a few words. This board, I believe, is going to consist of some members of the Harijan community and also a number of members belonging to non-Harijan communities. In any case, I would very much like that this board, which will of course function under the Home Ministry, should have as its chairman a non-Harijan. I want to stress this point because I know that in some of the states where the portfolio of Harijan welfare is given to a Harijan minister, he is not able to do his work properly. It is not because he cannot do it, it is not that he is not efficient enough to do it, but because every time he speaks about the welfare of scheduled caste and measures to be taken to improve their conditions, he is generally looked down by the other members of the cabinet as a communalist. If the same thing is done by a member belonging to a non-Harijan community, he will be considered to be doing a national service. Therefore, the chairmanship should go to a non-Harijan. The 10th 5-year plan, I understand, is going to be an industrial plan. Many industries are going to be established in this country. Therefore, I feel it my duty to say that the ministries concerned with heavy industries should take proper care in setting up new industries in places which are not very well developed. For instance, if a heavy industry is set up only in one state, all the ancillary factories crop up in that particular state and the benefits are derived only by the people of that state. Even in the case of employment in those factories, it is always observed that the people belonging to that particular state get the preference and the people belonging to other states do not get any benefit out of it. Therefore, the ministry should take proper care to see that these heavy industries are located in such places that they cater not only to one particular state but can also cater to more than one state. For instance, if a factory is located in the center of a state, the benefits of it will be derived only by the people of that particular state. There is a factory in Chennai, the Pelambur coach factory, which is producing coaches, that is located in the heart of the city of Chennai. It cannot help the people of either Andhra or Kerala. If the same factory were to be located on the borders, there may be so many ancillary industry feeder industries in Andhra or in Kerala. Because it is located in the heart of the city of Chennai, only the people of that state could make any profit out of it. Therefore, I appeal to the ministry concerned to take proper steps to locate the future industries in such places so that they could be of help not only to one state but be of help to more than one state. In Hyderabad, there is a place which produces thermal power, but there are no industries to make use of that power. Repeated requests have been made by the government of Hyderabad, but the ministry at the center is not at all taking any notice of it. I think if a factory to produce electrical goods or a small fertilizer factory or a small engineering factory were to be located at that particular place, that will be able to cater not only to the Hyderabad state but also to Andhra and other places as well. Therefore, it is necessary that steps should be taken to see that heavy industries are located not in one particular state but on the borders of states. Stop. Starting in 5 seconds. Mr. Deputy Chairman, the development of rural areas and improvement in the quality of life of the rural people has been of primary concern in the economic planning and development of the country. There is a growing realization that economic development and progress made by the nation in diverse fields would in reality be meaningless if they fail to translate it to better and dignified life for the majority living in rural India. In order to correct the developmental imbalances and to accord due priority to rural areas, the Ministry of Rural Development is implementing a number of programs aimed at development of rural areas with a focus on weaker sections. The rural development programs have been streamlined and strengthened. A number of initiatives have been taken by this ministry in the recent years for creation of social and economic infrastructure in rural areas to bridge the urban rural divide as well as to provide food security and to fulfill other basic needs of the rural poor. To match with economic liberalization and structural adjustment and to provide for safety, especially for rural poor, top priority has been accorded to rural development in terms of increasing the allocation of resources for the implementation of poverty alleviation programs. The allocation fund for the rural development programs has been increased for the 10th plan. The creation of employment opportunities with food security has been an important objective of developmental planning in India. The relatively higher growth of population and labor force has led to increase in the volume of unemployment and underemployment from the one plan period to another. With the working age population growing quite faster, the number of unemployed Indians is almost doubled. The declining employment rate shows that our growth process is failing. The real wages have been declining. The Government of India aims to bring employment through wage and self-employment into a larger focus with goal of reducing unemployment and underemployment to a negligible level and of providing food security against hunger. Such an approach is necessary because it is realized that larger and efficient use of available human and other resources is the most effective way of alleviating poverty, reducing inequalities, improving nutritional level, and achieving a reasonable high pace of economic growth. To make a tent on the prevailing poverty, unemployment, and slow growth in the rural economic, and to provide food security to facilitate faster growth in the rural areas and to increase opportunities of employment to provide greater importance of wage employment in rural areas. The National Rural Employment Guarantee Act was passed by the parliament for securing livelihood of the people in the rural areas by guaranteeing 100 days of employment in a financial year to a rural household. This act makes a shift in the whole strategy of existing wage employment programs because this act is not just a scheme, it provides a legal guarantee, it provides a social security for the weaker sections and opportunity to combine growth with equity in the process of employment generation assets which build up and strengthen the livelihood raise pace of the poor. Within 5 years, the act will be extended to the whole country. Sir, the National Food for Work program was launched in the year 2004 in the most backward districts of the country identified by the Planning Commission in consultation with the Government of India and state governments. The need for the new program was felt because the existing resources were not sufficient to meet the requirement of additional wage employment for most backward districts. Moreover, it was felt that additional resources should be used into some focus areas like drought and water conservation, which is the main problem in some states and a major cause of backwardness on certain regions. Some areas are flood prone and measures for flood control require special attention in these areas in a planned manner. The states were finding it difficult to provide state share funds and therefore a centrally sponsored scheme was proposed so that the investment in backward areas does not suffer because of lack of resources available with these states. The objective of the program is to provide additional resources, opportunities from resources available so that generation of supplementary wage employment and provide food security through creation of need-based economic, social and community assets in these districts is further intensified. Sir, now I come to the program which aims at building a nation with progressive and prosperous rural India. It will be a time bound plan in the areas of irrigation, road, rural housing and water supply. Government has set targets to be achieved under these goals. Stop.